Hi everyone, welcome back to the channel. This is Ishita, the legal intern and LEXIS and Company. Today I'm gonna tell you about the acquittal by Bennett of doubt. Why it is in news? The Supreme Court has held that a public employer can reject a candidate as unsuitable if she had in the past has been acquitted of a serious crime merely on the benefit of doubt. Benefit of doubt is granted to the accused when there is a total absence of evidence or in the criminal jurisprudence requiring the case to be proved beyond reasonable doubt. Key points in the background. The petitioner in the Supreme Court cleared the requirement for the post constable in Rajasthan Police Service. However, he was not appointed in view of being tried in a criminal case. It was found that though he was acquitted, the charges against him were not on a trivial nature but were serious offences, and the candidate was acquitted on the benefit of doubt. He was not only acquitted by the court. Supreme Court observation: the mere fact of an acquittal would not suffice, but rather it would depend on whether it can be a clean acquittal. Employers would be well within the rights to consider the antecedent and the acceptability of the candidate. In this context, the employer is entitled to take into account the job profile for which the selection is undertaken and the severity of the charge leveled against the candidate, and whether the acquittal in question was an honorable acquittal or was merely on the ground of benefit of doubt. An acquittal on the ground of benefit of doubt is quite different from an honorable acquittal. A person should be honorably acquitted of a heinous crime to be considered eligible for public employment. The code, however, reminded employees that rejection should not be mechanical, since employment opportunity is a scarce commodity in the country. Honorable acquittal and acquittal by extending the benefit of doubt. The trial court, after giving due consideration to the evidence placed on record and examining the witness, may do any of the things like convict the person, acquit the person unconditionally. In other words, it is an honorable acquittal. The term honorable acquittal is nowhere defined in the Indian laws, and it is the invention of Indian judiciary. An accused who is acquitted after full consideration of the prosecutive evidence and prosecution had merely failed to prove the charges leveled against the accused. Acquitting the person by extending the benefit of doubt or due to the failure of prosecution side to prove the guilt and beyond reasonable doubt. The mere fact of an acquittal would not suffice, but rather it would depend on whether it is a clean acquittal or not. Employers would be well within their right to consider the antecedent and suitability of the candidate, the severity of the charge leveled against the candidate, and whether the acquittal in question was an honorable acquittal or was merely on the benefit of doubt. So, the acquitting person be extending the benefit of doubt or due to the failure on the prosecution side to prove the guilty beyond the reasonable doubts. An accused who is accused after full consideration of prosecution evidence and prosecution has miserably failed to prove the charges leveled against the accused. The term honorable acquittal is the invention of Indian judiciary, as I told. However, the petitioner in the Supreme Court cleared the requirement for the post of constable in Rajasthan Police Service. He was not appointed in view of being tried in a criminal case. It was found that though he was acquitted, the charges against him was not of trivial nature, but were serious offences, and the was acquitted on the benefit of doubt. He was not honorably acquitted by the court. So guys, that was the benefit of doubt, which is very really unique topic. Not everyone heard about it. I hope you learned something very new today, and I hope you enjoyed the video. Please do like, share, comment, and subscribe the channel for further updates. Thank you.